Welcome back to Good Law, Bad Law. I am coming to you from the state of Vermont, where I am this week. We have an important episode, but I just want to note as a technical matter, first of all, you can see that I am in Vermont country attire, very, very happily so. If you're listening to the audio version of the podcast, there's no impact of my very poor internet connection here. But if you're watching us on YouTube, and I hope you will tell all your friends that we are now on YouTube, I think it's my video or my guest video will freeze for about a couple of minutes, but the audio is uninterrupted. And it's just life with a very lousy internet connection. What can I say? But the good news is that we have a fantastic conversation today with John Culhane, my guest. He is a professor of constitutional law at Widener Law School, part of the University of Delaware. Relevant this week as Joe Biden accepts the Democratic nomination this week of the Democratic National Convention. And we are talking about something too little discussed during this intensifying election season, which is what do we expect in the coming couple of years in terms of LGBTQ rights? And what are some of the issues that are going to be heard in the Supreme Court? What are some of the issues that the next president, whether it's Trump or Biden, will have a tremendous influence over? Everything from the intersection between religious freedom and the right to non-discrimination, a tension that we're seeing increasingly in some of the big Supreme Court cases in the last couple of years. What are some of the issues where executive action may become really important? The fate of the transgender community in terms of military service, for example. So as if you didn't need another reason why the election in just about 75 days is so important and is going to affect our lives depending on the outcome in innumerable ways. This episode is yet another subject that I think you really will be interested to learn about, as I have speaking with my guest, John Culhane. So everybody stay safe. Be well. Please register to vote if you've not done so, and make your plans today for how you are going to vote this November, whether it's by mail or in person. Please be engaged. Please be involved. Every vote does count. Stay tuned and enjoy this next episode of Good Law, Bad Law. My guest today is John Culhane. He is a professor of law at the Widener School of Law, the University of Delaware Widener School of Law. He teaches constitutional law and writes on a variety of topics, including issues involving individual rights and the intersection of those rights on LGBTQ families. He's the co-author, for example, of the Same-Sex Legal Kit for Dummies.
Yes, I have a book.
Yes, the latest in the Dummy series, and also as a contributing writer to Slate magazine. So first of all, John, thanks so much for being on Good Law, Bad Law today.
Thanks for having me. I appreciate it.
I'm in Vermont this week and I'm trying to dress the part in my Orvis wear. So I hope my poor internet connection will get us through this episode. But we have an important subject to talk about, and I really appreciate you being on the podcast to help us think through some of these issues. We're just this week having gotten through the Democratic National Convention, and next week will be the Republican Convention. And one of the issues that I haven't really heard a whole lot about this week is looking ahead at the two candidates, Donald Trump and Joe Biden, and the importance of the Supreme Court always on important cases involving individual rights. What kinds of issues do we see coming up starting next year, and in this area, in the area of LGBTQ rights? And how are people's decision this November going to have an impact on how some of those issues get decided and get handled? So that's very broadly what I was hoping we could talk about. And I don't know if you want to perhaps just kind of give us an overview and how you come to this issue, how this has been part of your scholarship and part of your writing and teaching, and maybe just give us an overview beyond what I've said to this point.
Sure, I'd be happy to. So, I first became interested in issues around the, gay, lesbian, and what sort of grew into the LGBTQ rights movement when I was arguing for the rights of same-sex couples to marry. That's kind of how it started.
Mhm.
And that's been achieved, and it was seen as a real watershed. It's an important victory, and there have been many important victories, both legislatively with things like the repeal of Don't Ask, Don't Tell, and of course through the Supreme Court with a whole series of decisions written by former Supreme Court Justice Anthony Kennedy, where in a string of cases recognizing the rights of same-sex couples to intimacy in their relationships, saying that the state of Colorado couldn't fence them out of equal protection under the law, and then in a couple of decisions, first eroding and then eliminating the ban on same-sex couple marriage. So that was a big victory. But even at the time in 2015, I wrote an article for Politico in which I sounded kind of a note of caution, saying, yeah, these are great victories, and this looks like the ultimate victory, but for gay and lesbian couples. But that doesn't mean that there won't be pushback and setbacks in other areas. And if you look at the composition of the current Supreme Court, a first look at it might suggest that the progress continues. We had a really important decision this past term in June, in which, or maybe it was early July, the calendar was a little different this year because of COVID,
Mhm.
but
Yes,
the court said that Title VII, which is the law that protects people in the workplace against discriminatory acts by the employer, protects on the basis of sexual orientation and gender identity. And that was
huge decision.
Yeah, it was a huge decision.
Yeah.
Because we had a patchwork of state laws before that, some states protecting people in the employment sphere, and about half the states still not doing that. And so this federalized these important protections in an opinion by Justice Gorsuch, in which he took a very textual approach.
Yes.
So for the non-lawyers, it's exactly what that sounds like, which is he looked at what Title VII says, and it says you can't, discriminate on the basis of sex. And he said, when an employee is fired or not promoted because that employee is gay or lesbian or transgendered, that's because of sex, in the sense that they're not conforming to their sexual identity as most people think of it, but also if they had been a member of the opposite sex, at least in the gender context, that discrimination would not have taken place. So it was 6-3 decision, with Justice Roberts joining Gorsuch and the 4 more liberal justices. And so it looks like, well, now we've got employment protection. Probably that's going to be a signal to extend protection to the educational context and other places as well, where federal law offers protection. But there was an important caveat that was expressed by Justice Gorsuch, where he said there are complicated issues that arise at the intersection of anti-discrimination and religious freedom and religious liberty. And so,
let me pause you there just for a second, because that's going to open up a pretty big array of issues that we know are coming.
Right.
And I just wanted to pause for a second, because I actually think Gorsuch's opinion is underappreciated, and I agree. I mean, I read the opinion, and I agree that he's taking a textual approach. He's looking at the language, and he's looking at the language of the statute and saying, okay, well, I kind of have to rule in this way because that's what the language of the statute says. And that's very consistent with his overall judicial philosophy, that you don't try to read into what the language of the statute clearly says. On the other hand, we're really taking a pretty big leap over what a lot of the thinking was leading up to that decision, because it doesn't say sexual orientation in the statute. It says sex. And
Right.
there was a clear group of judicial thinkers who said, well, when you see the word sex, that means gender.
Right. Right.
And so I think it's pretty impressive, actually. Not to say that there aren't going to be these clashes between religious freedom or religious rights and individual rights to be not discriminated against, but it's a pretty sweeping move for a textualist to have made in this case, I think. And that's why I think it's such a huge decision.
Oh, I agree. And I think, so I didn't mean to sort of glide past it so quickly. I think you're absolutely right. I think the smart money was that the case would go the other way, although during the oral argument, Gorsuch sort of said, I'm conflicted here because back when this law was passed in the 1960s, nobody was thinking about LGBT. They were thinking about discrimination against women in the workplace, right? And so he said, and this would be a huge change in the law. And on the other hand, I'm a textualist. He was sort of thinking out loud during the oral argument, and you didn't know how it was going to go.
Right.
I do think, though, that the fact that a number of circuit courts, federal courts of appeals, had found the same way that the term sex could be construed, maybe should be construed to cover sexual orientation, gender identity, gave the court at least some ballast for that decision, right? There were these cases, and also, as I said, about half the states, maybe slightly more than half the states, and certainly a lot of more populous areas like cities have these anti-discrimination laws already. So the kind of upheaval
that's where the movement has been.
Yeah, it's been moving in that direction.
Yeah.
It stalled out in Congress a number of times. And
Cowards.
Because I think they all probably, or certainly super majorities in both parties would favor it, but they're afraid of what might happen to them politically. So exactly. It's a huge decision, and I don't mean to underemphasize it.
Yeah, no, I wasn't saying you were either. I thought it's important because it does lead us into the next issue that you're raising, and one can easily imagine a case, although it wasn't in the case that Gorsuch decided. What if the employer, for example, is a company like Hobby Lobby or some other company where the ownership of the company has or is an actual religiously oriented organization and wants to discriminate in its employment? That's we haven't seen that case yet, but you can easily imagine how that case could be coming along, as well as a whole range of cases where that tends to play out.
That's right. So we could talk about a couple of those situations. So one is a case that the Supreme Court actually decided again this past term, where we had a teacher at a religious school that was really not teaching religious subjects. And she did a little bit of that, but basically she was a lay teacher, and the school fired her, and she claimed it was an age, discrimination claim, is what she claimed. And the Supreme Court had to decide whether the so-called ministerial exception to the anti-discrimination law applied. And what that exception says is that when you've got a religious organization with that as its principal or driving goal, they are exempt from the anti-discrimination laws for people that administer kind of the services or I guess have the jobs that are most closely related to that ministerial function. We think about ministerial, we think about it as kind of procedural, but they mean ministerial in the sense of minister, right? Somebody who's ministering to the flock. And a lot of people thought that this is really kind of a stretch in this case, that this woman was really not doing just because they said she had some, sort of connection to religious teaching. She wasn't teaching religion, and they all had to follow kind of the rules of the school, right, to talk about this stuff. But really, and what ends up happening in a case like this is a discrimination suit on a completely different issue. age discrimination. What that has to do with anything related to religion, I'll never know, right? But the court said, if the ministerial exception applies, it applies across the whole realm of anti-discrimination law. So it wasn't like they were firing her because she was a lesbian, for instance, and that went against the church teaching. It was completely unrelated to anything that the church would be concerned about, right? So, or the school, I should say, would be concerned about. And the dissenters say, well, one, she's too far removed from this, and two, this is the exception run amok. It could swallow the rule if we follow it this broadly. So that to me is an indication of how generously, at least from the religious perspective, the court is construing these religious liberties.
Well, we had the Colorado Bake Shop case, which is another example of that, where you see the court leaning very heavily on the religious liberty issue, where you have a tension between an individual liberty issue and a religious liberty issue. Yeah. And the fact that, I mean, it's interesting as you mentioned Justice Kennedy, and it's often thought that the Supreme Court moves at a glacial pace until it does something in a landmark way, and then there's this tremendous change take place. And so if you think about the Obergefell decision in 2015, which finally recognizes a constitutional right to same-sex marriage, and then these other decisions culminating in the Title VII case we were talking about, that's a pretty dramatic change in the last few years. On the other hand, Justice Kennedy is replaced by Justice Kavanaugh. And if anybody is thinking about whether their vote matters in November, here's a good reminder, right? I mean, it's the president that chooses Supreme Court seats. There's at least a couple of Supreme Court justices right now, including Justice Ginsburg, who I'm going to send thoughts and prayers to every day. Next president may well be replacing a so-called liberal justice on the court with a justice of their choosing. And these cases tend to be very close sometimes. So what do you see, I mean, other than sort of generally seeing the court wrestling with this tension between religion and the right to non-discrimination, are there particular areas that you think we could be seeing cases presenting this tension in the next couple of years?
Yeah, so I think there are a lot of cases like this, and a lot of them have kind of so far sort of flown under the radar. So let me sort of address a couple of different things. I mean, as Stephen Colbert said after Ruth Bader Ginsburg fell in her office, she said, well, what's she doing walking around in her office? She should be placed in bubble wrap and carried to the elevator. And she's having, she's got serious health issues. It is a little crazy that under our system, the fate of many huge issues is dependent on one or two Supreme Court justices and their health. And one of the things that's happened, not only at the Supreme Court level, but I think in some ways more importantly in the federal appellate and district courts, is that this president, when you look at the number of judges that he has put on the bench, in terms of the number of years he's been there, it's really unprecedented in terms of speed. And he's picking a lot of younger judges. And so the concern among more progressive people is that even if you got more progressive legislation passed or, something along those lines, a lot of it could be stymied by this new bench, which is now going to be in place for, 20, 30 years. So this is, so what happens in the next election, of course, is important, but it could take if a Joe Biden were elected, and then if the Democrats won for the next 12 years, it still wouldn't undo a lot of what's happened recently. And so that's a concern. And it hasn't been, the Supreme Court has not been much discussed in this, which I think is interesting. So let me say a couple of things. I do want to talk a little bit about the religious cases, and then I want to circle back to talk about the way in which the administration, whatever administration is in power, and the positions that they take really, to some extent, determine what the court's docket will be, or sort of influence the courts in their decisions. So maybe I can walk through those.
Yeah, I think that's right.
Okay, so in terms of the religious stuff, Justice Kennedy in the masterpiece Cakeshop case, which I wrote about in a couple of different places, really super interesting case. And basically the Supreme Court via Justice Kennedy punted. And what they ended up saying was, instead of resolving this tension between the Colorado anti-discrimination law, which protected on the basis of sexual orientation, and religious liberty, what the court ended up saying was, well, in this case, there was somebody on the State Civil Rights Commission that showed animosity toward the baker, and we're going to look at a different line of cases that say that if we can see the hand of animus against religion, then that basically disqualifies. In another case it was the law, in this case it was the ruling in favor of the same-sex couple. So
we never have to get to the bigger question.
That's right. The court never got there, and they can't avoid it for long, because, and it was Justice Kennedy's last term, and I think if you read his decisions over the last term, he was uncharacteristically cautious, and I think didn't want to be the fifth vote in favor of making gerrymandering more difficult, for example, right? Or extending the rights of LGBT people beyond where it had already gone. He just was trying to find ways to keep the status quo. And so in this case, I think what you're going to see going forward is all of these claims of religious liberty. Oh, I have a freedom, or if not religion, freedom of expression. Part of my expressive conduct is making this cake, right? And there's something expressive to it. That's
it was
agree with that. But
it was not a ridiculous argument. Yeah.
It's one of those things where it's hard to know what the stopping point would be. And I think people might have felt differently if it was an interracial couple that had gone in. Same law would apply, but we tend to look at those things differently still.
Yeah.
So it would put the court to difficult decisions. There's a case that the court is going to hear in the next term, which comes out of Philadelphia, where I'm sitting right now, in my home office, and, which is my only office these days. Right?
Right.
And it's a case that comes out of the foster care system in Philly, where a gay couple went to one of the agencies that has a contract with the city to place foster kids, and they were turned away because it's a religious, I believe Catholic, foster care organization, and they believe, as they have a right to believe in the abstract, that marriage is and parents should be a man and a woman, and very traditional. And so you have that balance between their religious freedom and the anti-discrimination law, which seems clearly to apply here. And the Supreme Court will take this up and decide how that balance is to be struck. My guess is that they will side with the religious organization and say that they still have a right to have a contract with the city. I mean, no one's driving them out of business. The question is whether they can have this contract that's supported by government funds. That's right.
Yep. Right.
And that's the issue. having as a former foster parent myself, we ended up adopting our kids out of the system. One of the things, I perhaps have a bit of a different view of this, or maybe a practical view, I should say, which is when you're dealing with a foster care agency, it's a very emotional, involved, intense, and lengthy experience, or it can be. And from my perspective, right, I wouldn't have wanted to go to an agency that was forced to take us on. And so what I always hope for in cases like this is a kind of, and I'll be vilified for this, but kind of a behind the scenes kind of market segmentation, where what ends up happening is, there's kind of a self-selection process. So the religious group never has to turn anybody away because the city funnels people in a certain way. And now you can't do it because the cat's out of the bag. But, you say, you got a gay couple, we'll just send them to X rather than there. And because obviously I think this foster care entity is probably doing a good job with the couples it's working with. But I see the bigger issue here as well, which is you can't turn people down just because of this and expect to get city funding. But I think the court will hold to the contrary in this case.
Yeah, I think you're right as far as how the court's likely to rule on that. And I'm disturbed, actually, that this case is coming out of Philadelphia, where I live as well. We did, actually, I was mentioning this to you earlier, we did an episode on this issue, but it was a Catholic child welfare agency, I think in Missouri or Tennessee or someplace like that. Not Philadelphia, my goodness.
Yeah, I know, right.
But if what you're saying, I hear you on the practical argument, and as long as there is a supply of agencies that people can choose to go to so that they're not limited
right
to the one that's discriminating against them on a practical level only, I guess it works. But if you make that argument, don't you also make the argument to the couple in Colorado?
Yeah, that's
and say, well, just go to a different bake shop if you want a wedding cake for a same-sex wedding. Or do you say to the interracial couple in Virginia or South Carolina or wherever that case was, if you want to have barbecue lunch, go to a different restaurant?
No. So I think those things are, so I think that is the argument against my position. And I understand that. And so ultimately, when push comes to shove, as it has here, I think the only proper way for the court to rule is like, this is a neutral anti-discrimination law. There's the Smith case from 1990 that says if you've got a neutral law that applies to everyone, the fact that it affects your religious beliefs more than it would somebody else's, tough. If you don't want to do that, you get into a different business.
Right.
All of that is true. The only point I guess I was making is that buying a cake, even a baroquely decorated cake, is to me quite a different thing than being in this long relationship with a foster care agency.
Yeah.
And so, maybe the answer is let the couple decide, right? So if the couple goes to the Catholic organization, knowing that they have these views, So let me put this in the context of Masterpiece Cakeshop, because I actually proposed a compromise, and in a law review article and in a Politico piece that I did on it. So my point, and it's a tricky point to make, but so this guy, Jack Phillips, who was the owner of the bake shop, I happen to recall the name because a close friend of mine has the same name. So yeah, so he I believe that he was a sincere person. I mean, he served gay and lesbian people all the time. It was just on the issue of a wedding cake that he had this exception. Now, my take on it is you do have a First Amendment right to express your opinion, right? But you don't have a First Amendment right to deny service. So for example, how would this work in the case? And it's a dangerous line to draw, because the effect could be, discrimination depending on how it's worded, right? But let's say on his website, let's say he has a website, I haven't checked.
Yeah.
It said something like, Masterpiece Cake Shop, Jack Phillips, believes in, traditional values, or whatever he wants to say. And one suggestion I had would be for states to create kind of a statutory safe harbor, where you could say this would, if you said something else, you'd be on your own. But if you said something, generic like that, then so if I went to the website looking for a wedding cake, I would think, I don't think so. Right? Now, some people pushing back on me said, well, then you just get people who would be litigating it or going in just to annoy, I said, there are those people, but I'm always looking for some kind of civility or compromise. And if this is really his position, if it's the only big shop in town, go bake the stupid cake and do it.
Right.
But if there's, if it's like Night of the Living Bake Shop and you've got 8 in the space of a 3-block radius, and the other 7 are like, we welcome all families, and this one is, I'm Jack Phillips and at the Fusty, bake shop case, then you don't go there. So I think, and I brought this up at a panel and I was excoriated, but I'm trying to figure out a way for us to coexist.
Well, that's the challenge. I think these cases are enormously complicated, because we obviously have, going back to the earliest days of our country, this powerful interest in religious freedom. I mean, it's in the First Amendment, not the 7th, 10th, or whatever, First Amendment, it's right there.
Right.
They obviously thought it was pretty important, and of course it is. And then we have this, this equally long but much more labored history and an evolving history of protecting individual liberties. So it's a real tension. I think that cake shop case, to me, is particularly tough, because they're private actors.
Right.
And to me, that makes it much more difficult than, say, the Philadelphia agency case, because just as you could say, an individual, a couple can go to some different agency, it is also true that the Catholic Church, if that's who's running this foster care agency that's at issue, they don't have to take city money.
Right.
That they can, that nobody is limiting them in terms of what they do and how they do it.
Right.
Except when you take public money.
Right. Right. Well, one thing, there are creative solutions. So in Peoria, will it play in Peoria? Here's something that played in Peoria. There was an organization, I believe they were Catholic, but some religious organization that would not place foster kids with same-sex couples. And so they just created a separate entity to deal with foster care that was sort of apart from the rest of their operations. And I thought that was, and that way they're more religious. Their other missions, whether it was Catholic Charities or whatever, they still did what they were doing, but they created this other thing that didn't. And I thought that was a really smart, practical solution. So those are the things that kind of appeal to me. And I'm sensitive to these interests on both sides. What I'm not sympathetic to is kind of eliminating the LGBT population from that equation, right? So it's we have to have 2 ears for this, and so I do think it's complicated, but if you're a bake shop, he might have made the same exact cake for, I had a debate with a Villanova professor about this, and I said, well, what would you say if one of them had gone in on his own and said, I want a cake for my wedding, and the baker didn't realize that it was a same-sex couple. Now he comes back to pick it up, and the cake's already designed. Now can you not sell it to him because he's part of it? He's already designed it.
Or he's already expressed himself.
He's already expressed himself. And
yeah.
So and so the guy didn't want to talk about that. He said, that's not this case. I said,
very good question.
Medical. I'm trying to figure out sort of like the limits of what you're saying. And he didn't have, and I said, or what if it was an interracial couple? He said, that would be different. I said, not under the prevailing Colorado law.
Mm-hmm.
And when you put sexual orientation into the anti-discrimination law, you're doing it precisely because you know it's necessary, that this is a group that requires protection, right? So, so that was kind of the point I was trying to make there.
Well, to just kind of tie up this section of our conversation, because I want to leave time to talk about executive/administrative table setting, issue setting, which we've seen more and more and more from our executives, whether Democrat or Republican. These are complicated issues. They're going to come up again and again in the coming years before the Supreme Court. The president, with a looser and looser role for the Senate in terms of advice and consent, mostly the president appointing members to the Supreme Court. So if you think these issues matter, and of course they do, and many, many other issues that the Supreme Court is going to take on in the years ahead, you might want to think about your vote in terms of who it will be choosing the next Supreme Court justice. So let's then switch to this. You can't pin this entirely on President Trump in terms of the method. His content has been very different, but it just seems like in the last, several administrations, as Congress has been, more knotted up than ever, presidents turn to executive action to do everything from set the terms of a debate politically to actually enacting law right from the White House. And that's right. That is good, depending on what day it is or which president it is, or it's bad, or maybe on a principled basis, it's just plain bad. I don't know, but so what do you think about that? And this president is really has made some pretty strong statements, some pretty disturbing statements on the issues we're talking about. Yeah.
So let me answer it in the context of a very specific example, which is the effectively ban of trans people serving in the military. And like so many other policy directives, it started with a tweet in 2017, where the president, out of nowhere, and apparently the higher ups in the military didn't even know this was coming, basically said that being trans is incompatible with military service, that it costs too much money and interferes with combat readiness. And so he was announcing this ban. For context, when the Congress under President Obama did away with the don't ask, don't tell policy to allow gay and lesbian people to serve, they did not include trans people in that. So their status was kind of up in the air. And so during the Obama administration, it was neither here nor there. So there was room for executive action. And in 2016, after a study that was commissioned by Obama with obviously his sympathetic people in place, right? They decide to lift the ban on trans people serving, and 2017, and so they had it ready to go. In 2017, Trump comes in and puts a stop to it. And so it's been working its way through the courts up and down. There were injunctions against the policy going into effect. The Supreme Court basically threw those out. And so the policy is in effect as the case works its way back up through the courts.
When you say the policy is in effect, you mean the Obama policy?
No, the Trump policy.
Oh.
the Trump policy is now in effect. So,
So currently, trans people are banned from military service.
So if they were already in before the policy went into effect, they're grandfathered in, as long as they don't now as long as they don't now come out as trans or try to get sexual reassignment or sexual confirmation surgery, as it's now typically called, right? So they're grandfathered in. But people that want to join the military or are already in the military who are now figuring this out, right? It's basically a don't ask, don't tell policy all over again. So as long as they're willing to live in their biological sex, which is not to them obviously who they are,
right? They're
okay. And also, though, if they have a diagnosis of gender dysphoria, they're not permitted to enlist. So even if they say, I'm going to live as my biological sex, if there's been that diagnosis, they won't let them in. Now, there are provisions for waivers, but they're complex. And as far as I know, that hasn't been happening. So it's kind of a mess right now. And, the House recently passed a bill. The Democratic-controlled House passed a bill to allow trans people to serve, and to quote, Amy Klobuchar, it's sitting on Mitch McConnell's desk. She said that many times during the campaign, and there are a lot of things sitting on his desk.
Yeah. Well, you teach constitutional law, John. I mean, for people who may not maybe understand fully or appreciate, I'm not sure I understand fully or appreciate the significance of this. As a constitutional matter, it's still surprising to me that the president, who doesn't make law, whose prime constitutional function is to enforce law, can make this law through executive action. So how, from the standpoint of constitutional law or separation of powers or fundamental functions of this branch versus that branch, I mean, should we, whether it's Obama doing it or Trump doing it, should we be concerned about lawmaking in this manner?
Yeah.
And not just because we don't happen to like this particular.
No, I get that. So I think what you're really asking is kind of the broadest question about the administrative state. And so what you have is you've got this lawmaking body called Congress, and then you've got the executive branch, including the president and his command over the military, right? And all of these administrative agencies that are not passing statutes, right? It's all under the executive branch, but they are effectively making laws that in many cases have, many times the impact of what the statutes say, because a lot of these statutes will be broadly drafted and leave plenty of discretion to the agencies that have the expertise that are charged with it. So, the Environmental Protection Agency or the Food and Drug Administration. I mean, I've named 2 out of 2 zillion, right?
But at least those, John, at least these administrative agencies, as you say, start with some, if broad and vague, nonetheless, some authorization from Congress, and then they go on and make rules and regulations and so on that have the look and smell of law. Right. But when Trump says, I have the power because I'm president, I can just do this, and he gets out his pen with his signature and he says, now I've made law. Right. I mean, that's something Congress never authorized.
Well, that's right. So I think one of the issues is, so if we go back, so this is nothing new, right? So if we go back before the don't ask, don't tell policy was put into place, right? There was a period of time where, gay and lesbian people were serving, right? And then there was a time when there was a policy that they weren't able to serve. So there was effectively a don't ask, don't tell. And then the idea was, well, we want gay and lesbian people to be in the military as long as we don't know who they are. It was not a sustainable policy in the long run. I regard it in retrospect as kind of a bridge policy to get to a point where, okay, they're here, they're queer, get used to it, sort of thing, right? I mean, right? At some point, that's what it is.
And that was Bill Clinton's policy, by the way. So
Right.
So you needed to have don't ask, don't tell, so that you can then not have don't ask, don't
That's
tell.
right. I mean,
Yeah.
it was, and Clinton wanted to just get rid of the ban, and he was not supported by higher ups in the military. So the compromise was this kind of clumsy thing. And what was really bad about it, of course, is how much you could tell kind of depended on your commander and where you were stationed or deployed, how much they needed you. So policies like that, my concern is always, in addition to the fundamental unfairness, kind of the unfairness that's born of discretion that kind of thing allows.
Right.
So that sort of thing, when it comes to the military in particular, in that area, the president does have a lot of power to set policy, as long as so the president couldn't now say, oh, by the way, gays and lesbians are banned from the military. No, there's a law that is to the contrary. But as long as there's not a law to the contrary, there is a lot of ability in sort of figuring out what military readiness requires that does fall to the executive. So how that plays out, and it's crazy that you can have Obama administration do this study that showed there'd be no impact. People like John McCain even signed on to it. And then you've got this other person who says, we don't like that study, where's the trash? We'll just throw that in there. And now we say no. And then if Biden comes in, which I think there's a good chance will happen, we could be back to where we were with Obama. I mean, it's a little, to use one of my favorite $10 words, it's vertiginous.
Right.
Right? It's dizzying.
Yes.
So I think in the military context in particular, there's always been a lot of discretion and a lot of ability to decide what military readiness requires, at least in the absence of the statute.
So other than the status of transgender individuals in the military, are there other LGBT issues that you think could go dramatically one way or the other, depending on whether Trump is reelected or Biden is elected to replace him?
Yeah, so there's one that's percolating right now through the courts that's interesting, involving immigration, where again, in the absence of legislation, the president has a lot of power. And so what you have in one well-known case out of Canada, you've got a case involving a gay couple and a case involving a lesbian couple. The case involving the gay couple involved two guys who were married, legally married in the US, and they went to Canada because they had a surrogate who was going to give birth to their child. The surrogate gave birth to the guy who was not a qualified citizen. Okay, so the biological father was the non-citizen of the couple.
I see.
And so the Trump administration has taken the position, and there was just a decision a month or two ago that just got appealed yesterday, where the Trump administration lost, and they're trying to appeal this either to a federal court en banc, right, a district court, or maybe to the Supreme Court. And what they're saying is you have to both, the parent of the child has to be biologically related.
Yes, that's what it comes down to.
That's what it comes down to. So it really has a disproportionate effect, of course, on gay couples, where only one of them obviously can be the biological parent. And the administration saying, well, we would apply the same thing to an opposite sex couple. But they might not know in that case, right? They they're not following it that closely. They'll see an opposite sex couple on a surrogate. They probably wouldn't ask any questions. But with a gay couple, you can focus right in on that. And there was a policy that was in place. The law is not clear. There was a policy that had been in place for decades that basically, said in that situation, we just have at least one parent is biologically related. The child is automatically a citizen. Now, of course, if the surrogacy had happened in the US, you wouldn't have this issue because the kid would be born in the US.
Right.
be like, Kamala Harris, a natural born citizen, and that would be the end of it, right? But
Or
because
to people crossing the border even illegally from Mexico, they have their child in Texas.
that's
That
right,
child
that's
is a
right,
citizen.
that's right.
But I don't know if you know the answer to this, but
Probably
I'm just
not.
curious, how does in this particular case, how does this even come to the attention of the immigration authorities that they can, so they have this baby through a surrogate in Canada, the child was born there, then they, I guess, try to come back into the US.
Which they can do because one is a citizen, they're married, right? They can
Right.
come back into the US. I don't know at what stage of the process, maybe something to do with the birth certificate. I honestly don't know the answer to
Well, that's
that.
what I was trying to imagine. Maybe they're applying for a social security card or something like that, but
Yeah,
so what? So they put down who the parents are, the legal parents are
but when they saw that,
these
maybe
two
they just,
men who are legally married.
yeah, well, that's the argument that they're legally married, and that should trump. It's a challenging word to use as a verb
Yeah.
these days. That should
We'll never know that. We'll never hear that word the same again.
should supersede any other considerations. And if they were an opposite sex couple, as a practical matter, it in all likelihood would.
But that's
So
what I'm wondering. So do they see two men's names and say, ooh, but like, what if the names on the birth certificate aren't names that are obviously biological?
yeah,
I'm going to
like
botch
Avery
the
or
right way to
something,
say that.
right? It's an Avery or somebody. Yeah,
Yeah.
I don't know. I mean, I think how much digging they did or how snoopy they were, I don't know. But
But I
it's
see the
certainly,
point. I mean, it really goes to the more fundamental issue that isn't so dependent on the facts, which is in a same-sex marriage, does the non-biological parent, by virtue of being legally married to the biological parent, legally have parental rights,
they
and does
do.
that child have
They
rights as
do.
the child of that person?
They definitely do under family law, which I also teach. That's
Yeah,
usually a no-brainer.
right.
But because immigration is weird anyway, right? In the sense that if two people are legally married, forget gender for a minute. Two people are legally married. There's no looking under the kind of marriage that they have, except in immigration, right? In immigration, the state will say, we think this is fraudulent. You're not
Yeah.
living in the same house. Usually they don't care. You could live on different planets for all they care. But in the context of immigration, because that is considered such a valuable commodity, that benefit of citizenship, that they
Yes,
do
I
take a
see.
closer look at it
That
in a
makes
bunch of different contexts.
that makes sense. Yeah. Well, there's a lot to say. A lot of these issues affect a lot of people, and affect, the fundamental issue that hopefully we're all engaged in a march towards, more and more progress in the name of, of individual rights in this country and respecting people for who they are, whoever they are. Um, just another conversation, I think, that shows the importance of this election, and I hope everybody is registering to vote. I'm just going to put my PSA out there: register to vote, and then vote however you do it. Just make sure everybody vote. And to my guest, John Culhane, thank you so much. This was a really great conversation. We
I
covered a lot,
enjoyed it.
and I really appreciate your time. Fantastic
Sure.
having you on the podcast. Thank you.
Thanks so much for having me. I appreciate it.